This is my.
Oh, it's very subtle.
Okay, we'll give it about 10 more seconds before we kick off. Hello, everyone. Thank you for those of you joining today who have registered for this event on our Export Roundtable, focusing on ways in which we can enhance the synergy between transitional justice and the Constitution drafting process. My name is Paul Williams, and I'm a professor of law at American University and the founder of the Public International Law and Policy Group. I will be moderating today's discussion and am honored to be guiding the conversation with my colleagues. This event is part of an ongoing project by the Global Initiative for Justice, Truth, and Reconciliation, which aims to enhance the synergies between transitional justice and constitution drafting in order to support stronger and more durable outcomes of these peace processes and these post-conflict transitions. Sarah Bradshaw, in a few moments, will be providing us an overview of the program of the Global Initiative. Now, our event today is co-sponsored by our friends at the International Coalition for the Sites of Conscience, the Center for the Study of Violence and Reconciliation based in South Africa, and the American Bar Association's Rule of Law initiative. Two necessary ingredients for a successful and durable post-conflict transition are transitional justice and a well-drafted post-conflict constitution. During this event, speakers will discuss challenges to integrating transitional justice into the constitution drafting process, highlight lessons learned from various state examples, and provide recommendations for how local actors may best enhance the synergy between transitional justice and constitution drafting within their country context. The roundtable will last an hour and will end on time. Today's event will be recorded and subsequently posted on our website and shared by our co-sponsors. We ask you to please submit any questions that you may have for our speakers using the Q&A function, and we will do our best to answer your questions throughout the event, either live or by typing answers into the Q&A. Now, let me introduce our panelists that I'm so excited to hear from. I want to first welcome Cora Andreou, a transitional justice expert specializing in transitional justice, conflict resolution, and reconciliation. Cora has directly worked for the operation of transitional justice and reconciliation processes and mechanisms in Tunisia, South Africa, Libya, and Mali. Specifically, Cora has worked for the Office of the High Commissioner for Human Rights in Tunisia, the United Nations Integrated Stabilization Mission in Mali, the United Nations Support Mission in Libya, and the Center for the Study of Violence and Reconciliation in South Africa. Welcome to the webinar, Cora.
Thank you. Hi, everyone.
Great. I also want to provide a warm welcome to Tom Cornell, an associate who is a barrister in the International Dispute Resolution Group at the international law firm of Debevoise and Plimpton. Tom is resident in London, where he represents corporate clients, sovereigns, and international organizations on a range of contentious and non-contentious matters, particularly investor-state arbitration, public international law disputes, commercial arbitration, litigation in the English courts, as well as extradition and related criminal investigations. Welcome to the program, Tom.
Thanks very much, Paul.
Yeah. We also are joined by Jonathan Warboys, a barrister in London and a senior legal advisor at the Public International Law and Policy Group. His practice focuses on international litigation and advisory work across all areas of public international law. He has acted as counsel in cases before the International Court of Justice, the International Criminal Court, the Kosovo Specialist Chambers. He has also acted for governments, opposition groups, and private parties during international negotiations, mediations, and cases before UN special procedures. Welcome, Jonathan.
Thank you very much, Paul. Very glad to be here.
And we've saved the best for last, Sarah Bradshaw. Sarah Bradshaw is joining us from the International Coalition for Sites of Conscience. As a program director for the Global Initiative for Justice, Truth, and Reconciliation, Sarah supports organizations and activists in conflict and post-conflict countries in using memory and memorialization-based tools to engage communities in coming to terms with the past and building futures based on justice and non-repetition. Sarah has worked on projects in Sri Lanka, Guinea, South Sudan, and the Gambia. Welcome, everyone, and thank you for agreeing to participate in today's panel. Now, before we begin with our Q&A, let me first invite Sarah to say a few words about the Global Initiative for Justice, Truth, and Reconciliation and this particular project. Essentially, a word from our sponsor. Sarah, over to you.
Thanks very much, Paul. So as Paul mentioned, the International Coalition of Sites of Conscience launched the Global Initiative for Justice, Truth, and Reconciliation, or GIJTR, in 2014 with 8 other international organizations. And together we implement rapid response as well as long-term phased programs that offer a holistic, integrative, and multidisciplinary approach to issues of truth, justice, and reconciliation. We work primarily with local populations, civil society organizations, survivors, and governments to develop transitional justice approaches that are victim-centered and collaborative, and that support dignity, respect, inclusion, and transparency in societies that are emerging from conflict or from periods of authoritative rule. And since the GIJTR's founding in 2014, we have collectively engaged with people from 72 countries, worked with over 700 CSOs, and have supported over 400 community-driven projects, as well as the collection of more than 6,000 narratives of human rights violations. We've also published 36 toolkits, reports, and other publications with our partners, many through projects such as the one that brings us together here today, that aim to contribute to the growth and development of the field of transitional justice through utilizing the GIJTR to feed into broader questions critical to the field. So this particular project built on an earlier GIJTR program that aimed to improve the ability of peace processes to establish robust, implementable transitional justice frameworks that are responsive to the needs of conflict-afflicted society, and particularly victims' perspectives. And you can find the reports that were developed from that project on the consortium's website, which is www.gijtr.org. So for this project, PRPG, who's the lead partner for this project, ICSC, and the Center for the Study of Violence and Reconciliation, along with the American Bar Association Rule of Law Initiative, identified findings and best practices on enhancing the synergies between constitution drafting and transitional justice through developing a series of case studies and a compendium of relevant literature, and by conducting 2 regional working group sessions with negotiators, members of mediation teams, legal professionals, civil society organizations, and representatives of victim and survivors groups. And then finally, on July 25th and 26th, we convened 25 of these stakeholders for a best practices and lessons learned workshop, which ultimately led to the guidelines that will be discussed here today. And with that said, just for a bit of more context, I'll turn it back to you, Paul.
Great. Thanks, Sarah. Now, there's an impressive work that the coalition has done since 2014 on all of these issues, and in particular on weaving transitional justice first into the peace process, and then what comes next, the post-conflict constitution drafting process. So let's kick this off with a question to Jonathan. Jonathan, let's look at this from 30,000 feet. Tell us about transitional justice and constitutions. What do you see as the value of exploring the links between transitional justice and post-conflict constitution drafting? And tell us a little bit more about the work that you and Sarah and our co-sponsors have been doing.
Well, thanks very much, Paul. And again, thank you to Sarah for the overview that was given. I mean, it's a really interesting question that you've asked, and indeed it's the whole point of why this has started and what it's really been looking into. And just a bit of context first. I mean, I've obviously been working on transitional justice and constitutions with PRPG and other organizations for many years. And I think one of the things we've seen as we've gone through the work we've been doing and spoken to many stakeholders is that often, despite there being lots of different opportunities for connection or synergies between the two processes, the processes often end up being either disconnected or there not being many synergies. And I think in part that is due to sort of the study of the subject not really being investigated in as much detail as perhaps it could. So one thing we've set out to do in this project, like Sarah said, is really go into the deep sort of connections between them and look for ways in which we can actually strengthen the processes, particularly from the perspectives of victims. And you know, it's been an interesting learning experience, which we've done through case studies, talking to many experts in regional sessions, like Sarah said, and people that have actually worked on these processes to try and understand what they did, what worked well, what didn't work well, for example, as well. And also in particular to try and understand the ways in which some of those successes and failures can be improved or built out into, like Sarah said, the best practices which we've produced. And what that's led us really is sort of thinking about the best practices in terms of how they may be, for example, like I said, focusing on victims in many respects, and, for example, empowering civil society, facilitating safeguards for individuals, focusing on sequencing, raising community awareness, and try to give sort of some options and best practices to people that are stakeholders, whoever those stakeholders may be, for example, whether it's governments or victims or civil society groups, and then to use those best practices to help them in their work. And what we're doing in practical steps from now on is we've got some basically best practice virtual learning sessions with groups that are in transitional justice and constitution processes or affiliated with them around the world. And we'll be, over the coming weeks, discussing the best practices that we've produced with them, getting some feedback and input on them, like we will from other experts today on this panel. And then there'll be some pilot projects where they try to implement some of the work or come up with ideas as to how they can improve the transitional justice and constitution interactions in their host countries. And what that will lead to is it will then lead to us refining slightly the best practices with a view to sort of going live, so to speak, in the beginning of 2023. And that's where we'll be producing, a bit like we have done on the previous project, Sarah said, a sort of list of best practices, and we'll certainly be coming up with those and circulating those amongst everyone who's here today. And just finally say that what I'm hoping to do today is sort of weave in some of the best practices and discuss those as we go through some of the questions and discussion, rather than sort of just listing them all off for you to make it slightly more interesting. So I hope that helps with the question, and thank you very much.
Great, thank you, Jonathan. Let's now turn to Cora. Cora, our audience members are tuning in from around the globe. Can you provide some background and a short overview of the Libyan constitutional process and how transitional justice has been woven into that process?
Thank you, Paul. Thanks everyone for joining in. I'm based in Tunisia now, but I've been working on Libya for 5 years. So just to give you a few elements of background about the Libyan process, which I will mostly be talking about today. It's not the perfect example, I don't think there are, but Libya is really on many aspects a counterexample, but I will try to draw some lessons learned and recommendations on the process. So as you know, there's a big legacy of human rights violations in Libya committed on all sides, some from years of dictatorship under the Gaddafi regime and others during the revolution in 2011, and also the civil war that followed, another civil war in 2014, and another one in 2020. So violations include missing persons, enforced disappearances, arbitrary execution, torture, sexual violence, spoliation of land, and so on. So right after the revolution, there was some hope for an actual transitional justice process and a constitutional process. But this all fell through in 2014 with the start of a new civil war and the blockage of the whole constitutional process and the closing of the Constitutional Court. But between 2011, or let's say 2012 and 2014, there were some laws related to transitional justice that were adopted, but they were not coordinated and they were rather fragmented. There's two transitional justice law in 2012 and 2013. I will come back on them later. There is a law for on missing persons and the search for missing persons that led to creating a commission for the search of missing persons. There is various laws on reparations, but they were all very fragmented. So they were all for specific categories of victims, which I think is not a best practice. So there's a law for reparations for political prisoners of Gaddafi. There is a law for a specific historical massacre in a prison called Abu Slim. There's also a draft law for compensating victims of sexual violence, and a very famous political isolation law, which was supposed to be the start of a vetting process, but was very problematic. And also, of course, we had many amnesty laws in Libya. The main limitations of all these laws is that it was one-sided and often politicized, meaning that it mostly sought to prosecute former regime crimes and gave amnesty to crimes committed by the revolutionary groups. What's interesting is that in 2012 until 2014, there was a victims movement in Libya, mostly families of missing persons, which I think is interesting to say because in many countries, it's families of missing persons who started movements for transitional justice, like in Morocco, in Argentina, and so on. So this existed in Libya. There were some demonstrations and so on, but then it kind of stopped. And now it's even more difficult for victims to claim transitional justice because of the security situation and also because of the control that is exerted on the civil society in general. But there are some initiatives, mostly at the local level, bottom-up, grassroots documentation and truth-seeking efforts. So this is what transitional justice is in Libya now. It's documenting crimes, but there's no real accountability, and it's not really coordinated, these various grassroots truth-seeking efforts. On top of this, there is, of course, international efforts, the ICC, the fact-finding mission, but this does not really lead to accountability so far. Just a few words on the constitutional process itself. So Libya does not have a permanent constitution. In 2011, the National Transitional Council, which was the transitional government, not elected, adopted in very quickly a constitutional declaration, which is very short, and it's not in no way an actual constitution. It just seeks like to, put some fundamental rights and protection of these rights, and then basic principles of the organization of power, but there's nothing resembling an actual constitution. There was a constitutional process, though, which is what I will be talking about, which is the election of an assembly to draft a constitution in 2014. But here again, the process was flawed from the beginning, partly because some ethnic minorities boycotted it from the start. And the draft that was produced by the Constitutional Drafting Assembly and voted by them in 2017 was never passed for referendum. So it was never really activated. And until now, there's no real constitution. So the only framework for Libya is this transitional constitutional declaration until now. So all of this, the lack of accountability, the absence of a permanent constitutional framework, this led to a cycle of violence and instability in Libya. And we are witnessing it until now with discovery of mass graves near the capital, Tripoli. And I think one of the main obstacles, which I will discuss later, besides the lack of political will, is that the justice system itself is unable to ensure any accountability for these violations. because of its capacity, because of insecurity, and also because of the legal framework. In Libya, it cannot deal with these type of crimes. It's not defined in the penal code, and when it's defined, it's not in line with international definition. There's no crime against humanity, there's no war crime in Libyan law. So all of this is obstacle to accountability. And the lack of a permanent constitution is also one obstacle to peace and to holding of elections and ending the transitional period. So later I will try to argue in favor of enhancing synergies between transitional justice and the constitutional drafting process in Libya as part of a new political dialogue, which should take place soon. And I will try to talk to you about how this can be done.
Great. Thank you, Cora. Let's now turn to Tom. Tom, I understand you're familiar with several constitution drafting and transitional justice processes around the globe. Could you say a little bit about the constitutional drafting and transitional justice synergy in the states that you are familiar with?
Sure. Thanks, Paul, and thanks to PILPG for hosting this event. I suppose just looking, sort of stepping back and considering some of the jurisdictions that we've studied, I suppose in terms of synergies, I mean, it's fair to say that there's a spectrum of interconnectedness. I think at one end, you have sort of complete disconnection between the two processes, between constitution drafting on the one hand and transitional justice on the other. And then at the other end of the spectrum, you've got pretty substantial integration. And a lot of the situations we've looked at sort of fall somewhere in between. So just sort of looking at two fairly comparable situations, Colombia and Nepal, that we've looked at, both states that suffered protracted internal conflicts between various political and militant groups. So just sort of looking firstly at Nepal, and I'll just sort of summarize what we've learned from looking at that jurisdiction, and then make some general observations. So obviously Nepal, there was a decade-long civil war between 96 and 2006. A comprehensive peace accord entered into in 2006, followed by an interim constitution in 2007. The interim constitution referred to transitional justice and the need to create a Truth and Reconciliation Commission. But that's really about it. So it was a sort of reference to transitional justice, but not much more than that. The Constitution was finally enacted in 2015, and that, in fact, didn't refer to transitional justice at all. So I think Nepal is an example of a country where the transitional justice mechanisms were kept away from the constitutional drafting process. So going back to the spectrum I set out at the beginning, I think this is an example of a jurisdiction where there was little to no synergy between the two processes. So just sort of following on from that and taking a bit further, sticking with Nepal, two transitional justice commissions were eventually created in 2015 pursuant to separate legislation. So that's not under the Constitution. You had on the one hand the Truth and Reconciliation Commission, and on the other, the Commission on the Investigation of Enforced Disappeared Persons. They were originally given 2-year mandates. The mandates had to be extended multiple times. There still haven't been any hearings, let alone completed investigations or reports. So perhaps unsurprisingly, the transitional justice in Nepal has been criticized, including by the Office of the United Nations High Commission for Human Rights, which in 2016 stated that it couldn't support the commissions because of their lack of impartiality and failures to meet basic international standards. It seems that not much has changed since then, at least according to a report published in 2020 by the Human Rights Justice Center and Trial International. So again, just stepping back and thinking about Nepal, and whilst it's important not to rush to conclusions or draw causal connections where those might not exist, I think it's fair to say, firstly, that the transitional justice process has been kept separate from the constitutional drafting process. And secondly, that the transitional justice process in Nepal hasn't been an overwhelming success. So that's, I suppose, one end of the spectrum. And then moving quickly to the other end of the spectrum, or at least further towards the other end of the spectrum, we've looked at Colombia. Of course, Colombia, again, protracted internal conflict, over 50 years long. Constitution enacted in 1991 after a peace agreement with one of the militant groups, M19. That constitution emphasized peace and guaranteed political participation of all groups, but no real reference to transitional justice. That changed in 2012 with amendments to the constitution to grant Congress powers, for example, to create judicial and extrajudicial procedures for prosecuting crimes and clarifying the truth. And then really in 2017, you have a second set of amendments that set out a comprehensive system of truth, justice, reparation, and non-recurrence. I think that's really the amendments that set the transitional justice process in Colombia on a sort of constitutional footing. And that framework included both a Truth and Reconciliation Commission and a special jurisdiction for peace. And just looking at each of those briefly, the Truth and Reconciliation Commission published a final report earlier this year, and that was a comprehensive report. And then looking at the other, the Special Jurisdiction for Peace, that's ongoing, but there were hearings this year. And during one of those hearings, for example, there was a confession by 10 retired members of the Colombian military regarding extrajudicial killings. And that was said to be the first time perpetrators had admitted to committing war crimes in the context of a court created by a peace accord. So again, a long way to go, but I think that shows a significant measure of success by the general standards of transitional justice mechanisms around the world. So looking at those two situations, and very briefly making a couple of final observations. One, I think the processes are not, transitional justice and constitution drafting are two processes that aren't necessarily linked to one another. And in fact, often that's not the case. That will have a lot to do with the aims of the participants involved. And I think, although the processes usually share the long-term goal of achieving peace, there is an undeniable tension between the two. For example, transitional justice seeking justice and accountability, constitution drafting necessarily being a political process driven by potentially rival interests of different political factions. So recognizing that tension, however, there is scope for transitional justice to be included in a constitutional framework. And we've seen that happen, and it's possible for the two processes, I think, to dovetail with one another. Colombia is a good example of that. And finally, I think the constitutional underpinning of transitional justice does seem to help, again, very broadly, and it may seem an obvious point, but the case studies we've looked at certainly indicate that it is much more difficult for political elites to ignore transitional justice, where that process is anchored in the country's constitutional framework. Again, Colombia, a very good example of that. So I think that's a sort of whistle-stop tour, but I'll hand back to you, Paul.
Great. Thank you, Tom. I wanted to pick up on your penultimate observation and put it to Jonathan for some concrete recommendations. You noted that there really isn't a lot of synergy between transitional justice and post-conflict constitution drafting, but that there is some hope given the Colombia process. But Jonathan, you're a barrister. You have clients. If your pro bono clients are stakeholders, victims groups, civil society, the parties, how would you advise them to develop the synergy and to link transitional justice and the post-conflict constitution drafting process?
Yeah, it's a really good question, Paul, and it's a practical question which I'm sure we'll have to confront at some point with clients. I think what we've come up with in recommendations, at least, is looking at, for example, some key themes which I think are really important. And one of the first ones that jumps out at me is sort of the sequencing and how you plan and how you sequence. And Gambia is quite a good example of how you can get involved in a preparatory phase, for example, as well as Yemen. And in Gambia, for example, there's sort of a national stakeholder conference. And that's like a prelude to, in essence, transitional justice starting and all the constitution process starting. And that almost starts off a process. And I think on sequencing, where we've come out, at least in some of our recommendations, is things like consider first whether, for example, practically an interim constitution might help. It can help in certain instances, like I think in South Africa, it was a good example of where, for instance, you had an interim constitution which paved the way for transitional justice and constitutional reform that then kept going and changed maybe the nature of society. In other situations, though, it can go the other way. And, I'm sure you're very familiar with Bosnia, for example, and that can be a situation where sometimes it gets fixed. And then also, I think another thing which we've come up with in the recommendations is sort of define and settle expectations before you're implemented. And I think this is as much a practical point as it is anything, but you obviously need to know where you're going and map it out. And I think that's deeply linked to the point about wide consultations. And that's something else, and victim-led processes, which we've actually drawn out in this. And another thing which we've really focused on in the recommendations when thinking about how you can actually link and move forward transitional justice and constitution drafting is about, like Tom said, sort of how you ensure that there is actual legal force given to constitutional steps. And one option which you can do is to, for example, give in a constitution, give legal force to transitional justice processes that will then pave the way for how things go. So I think those are sort of some very brief remarks on sort of how I would recommend people linking. And I think it's really trying to approach it in a methodical way. But it also needs to take account, obviously, of the politics, which in many situations can be fairly complex.
Thanks, Jonathan. That's helpful advice to those stakeholders seeking to develop that synergy between post-conflict constitutions and transitional justice. Cora, let's turn back to you. You previewed some of the difficulties and opportunities in Libya, and I'm interested to hear more about the links and interactions between transitional justice and post-conflict constitution drafting in Libya. What were the key instances of interaction between transitional justice and constitution drafting in Libya, and what lessons can we learn from that?
Thanks, Paul. Again, I'm talking on Libya as in a very abstract way, because, as I said, there's no process on both sides, but I will talk of the existing text. And I think I identified two main examples of interaction. The first one, which I think is interesting because we've seen the same trend in Tunisia, and I wonder if maybe participants or panelists have seen it in other countries. So the first interaction is the tendency to amend the constitution in order to protect transitional justice measures from future legal or constitutional challenges. And I think that's really interesting because it really exemplifies the differences between transitional justice and constitution. Transitional justice, by definition, is temporary, is some form of exceptional framework, whereas constitution should be permanent and more lasting. So in Libya specifically, it's very paradoxical that there has been some amendment to the constitutional declaration to protect transitional justice related laws or decrees from legal challenges, because in Libya, there's no constitutional court or active one, at least until recently, to arbitrate these challenges anyway. Since 2014. That's a very important point to keep in mind. An example of this is the political isolation law. So I put it under transitional justice, even though it's a flawed law, and all the international community back then said that it was against international standards and so on. And it was indeed problematic, but it was some form of attempt to do a vetting of the public sector and to contribute to non-repetition. Why I say that it was problematic and discriminatory is because the law basically very broadly disqualified from public position and also some private sector position anyone who committed violations under Gaddafi era, but also there were some more broad definitions, such as people who glorified Gaddafi, for instance, which is not a crime and under any existing law, but this would be a criteria to remove people from their position. So this is because of this wide definition, it created a lot of tension, of course, in Libya, even led to violence. But to avoid any legal or constitutional challenges to the law, the GNC, which was the parliament at the time, passed a constitutional amendment to say that isolation, this political isolation, was not a violation of the rights contained in the constitutional declaration. So they passed an amendment to say that anything that's in the political isolation law is not to be considered to violate rights in the protected by the constitutional declaration, as the right to a fair trial, or presumption of innocence, or non-discrimination, and so on. So it's an interesting example of how constitutional processes can interfere with the issuing of transitional justice-related law and try to protect it from any arguments of anti-constitutionality. And I said before, and maybe I'm happy to talk about it later because I worked on it too. In Tunisia, the same was observed. So the 2014 constitution in Tunisia, which sadly is no longer Tunisia's constitution, included the last paragraph actually of it was to say basically that transitional justice, for anything related to transitional justice, the principle of non-retroactivity of law and prescription and other basic fair trial principles do not apply. So this was to make sure that transitional justice process, which included special chambers and truth commission, that they would be able to prosecute crimes committed even besides the prescription time frame, and even if these people were already judged and so on. So this was an interesting kind of mental exercise. The second interaction is the fact that some TJ measures can be integrated in constitutional documents or framework. And I think this is more common, and we have seen it in more cases. And in Libya, it actually exists. Where I've seen it is not in the Constitutional Declaration, the 2011 document, but in the 2015 Libyan Political Agreement, which is a peace agreement which was signed in Morocco, but it was included in the Constitutional Declaration in 2019. So we can consider that this peace agreement is part of Libya's constitution, which is interesting in itself. And it contains a whole set of principles of commitment to transitional justice. It includes implementing the transitional justice law, searching for missing persons, providing the return of all IDPs, reforming justice sector ensuring accountability, and so on. And the same can be seen in the 2017 proposal of the Constitutional Drafting Assembly, which I mentioned earlier, which also includes several transitional justice-related measures. It calls for prosecuting crimes against humanity, for guarantees of non-repetition, truth-seeking, and some form of SSR or DDR program. But in both cases, the inclusion did not lead to any implementation. And I think one of the reasons, and this is maybe a lessons learned, is that the way these measures were formulated, especially in the LPA, the Libyan Political Agreement, were very general, and there was no real step for implementation. There was no timeline for when the actual law should be implemented, and so on. And the fact that Libya doesn't have an active and legitimate parliament is also another big obstacle. But maybe we could think that as Libya embarks on the process of revising its constitutional draft or issuing a new constitutional basis, which is part of the current political dialogue, maybe stronger, more precise measures to protect transitional justice from future constitutional challenges, and also to provide like a strong set of principles and rights for the future transitional justice process. This should be something to consider.
Thanks,
I can talk of, yeah, no problem. I can talk of the success and failure, or I keep it for later. Yeah.
Go ahead and jump in on the success and failure.
Okay, so as I said in the beginning, I think one of the main limitations of the Libya process, both for the constitutional process and the transitional justice process, is the lack of consultations with victims groups and with civil society in general. And as we know, it's considered as a good practice to have an inclusive process and have victims participate. One of the reasons, there's many reasons for it. I think it's, as I said earlier, it's harder and harder for Libyan civil society to actively take part in any civic engagement, including transitional justice, because it's especially transitional justice, because of the sensitivity of the topic And the fact that because there's been no vetting, people who could be prosecuted or considered as criminals are still around, militias are still around, and there was no justice. So this makes it very hard for Libyan activists to push for a transitional justice process. There's also a cultural element, I think, because the identifying themselves as victims or a victims group, we have seen it a lot in Tunisia, but in Libya, it's not something that I've ever really witnessed. Another failure, I think, is that so far transitional justice laws and measures were also too often one-sided. And as I said in the beginning, they protected the revolutionaries and they preserved impunity. So it was seen as one-sided. Amnesty laws, for instance, only applied to some crimes committed by a former regime and not to others. So this clearly goes against due process, non-discrimination principles, which are protected by Libya's constitutional declaration now. And also it goes against fair trial principle, of course. One thing I wanted to say is that I think this, and this can be maybe applied to other countries, obstacles to holding perpetrators accountable to crimes in Libya. One of them, of course, is statutory limitations. In Libya, it's 10 years, according to the penal code. And because there's no definition of international crimes or crimes against humanity in Libya's national legislation, the 10 years will apply to most crimes. And it was applied in 2019 to acquit the defendants in a case related to a massacre in a prison under Gaddafi, the Abu Salim case. So all of this goes against, of course, Libya's international law obligation. So this really points again to what I said about the inadequacy of the existing legal framework in Libya to allow for actual transitional justice, because these crimes are either absent of Libya's penal code or, the statute of limitation would apply.
Great. Thank you, Cora. No, that was very helpful in terms of getting into the very, granular successes, failures, best practices, or not best practices in Libya. Let me now turn to you, Tom, and you've done quite a bit of, research and engagement around the globe. Share with us 3 recommendations or best practices that you have for integrating transitional justice and post-conflict constitution drafting.
Sure. Thanks, Paul. I'll try to keep my answer a bit brief at this time. So I think number one, and this is following on from something that Cora's just said, I think it's important to try to keep both processes, that's constitution drafting and transitional justice, as open and transparent as possible. I think it's essential to keep the debate going and ensure that as many people as possible are aware of both processes. And so number 2, and I think linked to the first point, I think keep participation as wide as possible. I think, again, from the case studies I've looked at, it's clear that mass participation is often very difficult to organize. But I think despite that burden, it's important that both constitution drafting and transitional justice try and ensure as wide a participation as possible within the country in question. And then number 3, and this is probably the most obvious one, I think try to coordinate the 2 processes to the greatest extent possible. Bearing in mind, of course, that even some measure of interconnectedness between the 2 processes can be beneficial. So I think earlier I gave the example of Nepal being somewhere where there was very limited integration between the 2 processes. I think even some cooperation and coordination can be beneficial, and you see that, for example, in Timor-Leste. Although some commentators have said that transitional justice mechanisms in that country could have benefited from more explicit and specific support in the constitution. So, for example, some say the constitution could have provided concrete guidelines for transitional justice processes. I think, having said that, the limited references in the 2002 constitution in Timor-Leste to transitional justice did at least keep momentum going. So, for example, the Commission for Reception, Truth and Reconciliation conducted multiple public hearings after the constitution was enacted, and the final report was published in 2005. So I think some, albeit limited, similarities with Colombia, but I think, again, broadly, number 3 would be try to ensure some level of integration.
Thank you, Tom. Let's now turn, we have two questions from two former ambassadors in our Q&A. So let's turn to the first question from Ambassador Zorza Maric, and she wants to know, for all of the panelists or whomever would like to take this question, can you highlight specifics on the potential power of combining transitional justice and constitution building to achieve conflict prevention and promote sustainable peace? What are the biggest challenges inherent in combining these two processes? Who wants to jump in on that?
Well, I'll jump in very briefly on the first part, I think. I think it's a really good question and something certainly I've considered when we've been doing this work and when we've been doing the recommendations is exactly that. How do we contribute ultimately to durable peace? And I think one big aspect of the work we've done and part of the focus and also the recommendations is really involving victims. And I think it's something which is coming out through what Cora and Tom were saying as well, and a broad section of society. And I think personally, one way in which you can improve, and certainly one of the group's recommendations we fleshed out, is really by involving victims in the process, like I said, and that could be empowering civil society victims early on in the process. It's going to be much more meaningful, like Tom and Cora said, if they're involved. Facilitating safeguards as well, that's really key, whether it's in a constitution drafting process when you're being consulted, or in a transitional justice process, particularly when there's sort of sexual gender-based violence in a conflict. And also ensuring you've got really concrete plans for outreach, and that outreach brings people together. And it's not based on empirical data, but I do think that if you do move in these directions, it will show positive signs, and it can help with that overall reconciliation and bringing everyone together through both the constitution and the transitional justice drafting process.
Thanks, Jonathan. Cora or Tom, did you want to jump in as well?
Yeah, I can talk a bit about the combination of both and the challenges. I think one is, maybe it's a conceptual challenge, but I think it's important, and I try to show example of this from Libya, is transitional justice by definition will be focused on victims, perpetrators, and is temporary, and constitutions are meant for society as a whole. So this can lead to conceptual and legal contradiction, and this can feed some form of instability, especially in relation to due process guarantees and non-discrimination principles, I think. And so there's been some attempt in Tunisia and Libya as well to go around this challenge by, as I said, including some constitutional amendment or provisions in the constitution to protect transitional justice against these arguments. On the idea of sequencing, I think just a few remarks that maybe can help the discussion. There's different aspects to it. So either transitional justice is before constitutional drafting. In this case, maybe it can give a better foundation for the constitution process, because it gives it a more meaning. It's meant to repair past abuse. And for instance, a Truth Commission can make recommendations on future constitutional reforms that are needed, and can carry the momentum of transitional justice in the future, basically, and make a temporary process into a longer term effort. Another situation is that constitution building is before transitional justice. And in this case, the constitutional process can consolidate transition, create more stability. So this will all be good for the future transitional justice process. I personally think that for Libya, this should be required. And in this case, also, there can be a better legal framework within which transitional justice can take place, which, as I said, in Libya, I think is the main challenge. So to do so, we can include, one solution is to include, as I said, a clause on transitional justice in the future constitution to protect it in the future. Or the last option is to have both at the same time and reinforce each other, which is also, I don't know if there's any cases where this happened. I think perhaps it will happen in Libya, I hope, if this is the case. And in this case, there are some good synergies. One of them is that transitional justice needs a strong constitution to rebuild civic trust and rule of law. All of this is part of its long-term objectives. And reversely, a constitutional drafting process needs to go beyond just writing a new document, but actually be seen as a founding moment for a new society, or something that requires a social transformation. And actually, often we can see in the preamble of constitution, like in Tunisia, but also in Libya, they include like a new social narrative about the past. So this is a strong link also, and an argument maybe in favor of synergies.
Thank you, Cora. Let's go ahead now and turn to our second question, which comes from former Ambassador Yvette Stevens. Often in peace negotiations, amnesty is granted to warring parties, as this is considered important in bringing peace. In these situations, some of the worst offenders are not subject to transitional justice. Can anything be done in such situations in post-conflict constitution drafting to address these situations and avoid a recurrence of conflict? Any takers on that question? Jonathan, I see you're raising your hand. Off to you.
I'll be brief and come in. I mean, amnesties, I think, is a really interesting question. One we're grappling with in other work, as you all know, Paul, and it's something that really does require careful consideration. Especially through our colleagues at CSVR, we looked at the South Africa case study in our work, and amnesties obviously is key in that. And Ambassador Stevens, you'll also have familiarity, obviously, with amnesties as well. I think where we came out on amnesties in terms of the recommendations, at least, and how it can maybe help is, and it's a two-part recommendation from me, at least, which was, in the first part, it does sound slightly obvious, but I think it is really important. I think the first one is you've got to apply international law when it comes to amnesties, and be guided by international law. And there's obviously a temptation, either when you're granting an amnesty in the constitution, like in South Africa, or engaging in a transitional justice program, to sort of just do it in the abstract without really thinking necessarily about what the international law implications are. So I think that's the first part. And the second part, which really came out of our work, and I think is fundamentally important, is that if you're going to have amnesties, they need to basically have been driven by victims as well, and victims need to be consulted. We, like the question really gets at, you can sometimes see amnesties as being something between just the conflicting parties, and that is not going to solve long-term durability. So that's how we've sort of tackled that question head on in our recommendations.
Tom or Cora, did you want to jump in on that question of amnesties as well?
Yeah, I just jumping in briefly. I mean, I agree with everything Jonathan has just said, and I think it is a very delicate balance to try to strike. And I think I mentioned at the beginning that there is this inherent tension often between the two processes of constitution drafting and transitional justice. I mean, Colombia, again, I think the process hasn't come to an end yet, but I think there are indications that perhaps a balance can be drawn in these delicate situations. And I think, just picking up on what Jonathan said about the importance of having victim-driven programs, I think certainly the Colombian process has emphasized the participation of victims. And really, for example, the hearing in April this year was, victims were present, and the entire sort of setup of the process was very much focused on accountability to victims. And it was in that context, I think, that the confessions emerged. And so if that difficult balance is going to be addressed, I think it has to be done, as Jonathan says, in a way that respects international law and really is driven by victims.
Thanks, Tom. Cora, go ahead, jump on in.
Yeah, just to add on, again, the Libyan example. So as I said in the beginning, there's various amnesty laws that were passed in Libya. And indeed, the argument was that this was supposed to help for the peace process, but they were mostly one-sided. So it's also an issue when you only give amnesty to certain political groups and not the others. But this can be potentially overturned by a constitutional provision. As I said, non-discrimination principle, first of all. So in Libya, this is what was witnessed. So I think this is an interesting example. And actually, the amnesty laws were there was then a general to overcome this. The solution was not good. There was, instead of having partial amnesty for some groups and not others, there was a general amnesty law in 2015, which was de facto implemented. So this is not also a solution, but also I think potentially a new constitution, if it has strong provision on the definition of international crime and the status of international law versus national one, and statute of limitations and how they apply to these international crimes, all of this could potentially reverse any amnesty law from the past. So in this sense, having no constitution yet is maybe an opportunity for Libya. So this is what I wanted just to end with, is that maybe I've sounded like it's a missed opportunity, but it's also a chance because it's a blank state basically. So now there's an effort to write a new transitional justice law by the Presidential Council in Libya, and they try to have some more inclusive process. I hope there will be a new constitutional process, but I think we have learned in Libya, at least people who work on Libya, if there's anyone here, some lessons is that the importance of both processes. And I think they are really, as I said, really linked together. We have seen it very dramatically last year when the election failed and when there were elections planned on 24 December 2021, and it did not take place. And I think it's partly due to the lack of transitional justice and constitution, because you can't elect a president in a very fragile state without a permanent constitution, because what you risk to repeat the same mistakes. So this relates to non-repetition. You will elect someone with unchecked executive power in a legal vacuum. So no one wants this. And it also showed the failure of elections, how transitional justice is important to election itself, because it can ensure that people who are affiliated with former regime or under criminal investigations, such as Gaddafi's son, Saif al-Islam, would not be allowed to run. And transitional justice also can build the required civil trust and the rule of law, which is necessary for elections to take place and to be fair. So even when you look from an electoral perspective, transitional justice and constitution are really important and related. So I really hope that this can be an opportunity to consider both ethical and political benefits of an inclusive constitutional building and transitional justice processes. I wish there are good examples from across the world, but I think these two processes have really similar goals of reforming state institutions, writing a new national narrative, and of course, guaranteeing the non-recurrence of past violations. So I hope this can be an opportunity.
No, thank you, Cora. I think you summed it up nicely when we're in a particularly unique situation where, although there have been a number of missed opportunities in Libya, Nepal, we could talk about Sudan, South Sudan, other places, it's unique in that there are recurring opportunities. It's not really a one-off. We see that post-conflict constitution drafting, post-conflict governments oftentimes creates opportunities to revisit transitional justice. And so even if our colleagues and friends miss an opportunity at integrating TJ into the constitutional process, frequently we see that there's a mulligan or a do-over. Well, that's all we have time for today. I'm deeply grateful to Cora, Tom, Jonathan, and Sarah for taking the time today to share with us their thoughts on the possibilities for enhancing the synergies between post-conflict constitution drafting and the transitional justice processes. Despite having worked on a number of post-conflict constitutions and designing transitional justice processes, I've learned a tremendous amount today in great detail on Libya, and then with the ARC with Jonathan and Tom from around the globe. I'm deeply grateful to our co-sponsors for this event. I would like to thank the International Coalition for the Sites of Conscience and the Center for the Study of Violence and Reconciliation and the American Bar Association's Rule of Law Initiative. I'm really looking forward to the best practices guide that the Global Initiative for Justice and Truth and Reconciliation will be putting out shortly. And thanks to all of you who've joined us for our PILPG Thought Leadership on a Friday afternoon and Friday evening. Have a great weekend.
Thank you. Bye.
Thank you, everyone.
Bye-bye.
Thank you.